AI is transforming customer service. It's real and it works. And with Fin, we've built the #1 AI agent for customer service. We're seeing lots of cases where it's solving up to 90% of real queries for real businesses. This includes the real-world, complex stuff like issuing a refund or cancelling an order. And we also see it when Fin goes up against competitors. It's top of all the performance benchmarks, top of the G2 leaderboard, and if you're not happy, we'll refund you up to $1 million, which I think says it all. Check it out for yourself at fin.ai.
Here at Blue Apron, we know exactly how hectic school nights can be. That's why we created Assemble and Bake. Delicious one-pan meals that make family dinner simple. Just assemble the pre-chopped ingredients and put the pan in the oven to bake. Then you're free to help out with that last-minute diorama. Shop Assemble and Bake at blueapron.com. Get 50% off your first 2 orders with code APRON50. Terms and conditions apply. Visit blueapron.com/terms for more.
This is Amicus, Slate's podcast about the courts, the law, and the Supreme Court. I'm Mark Joseph Stern, in for Dahlia, who's off this week. Don't worry, she's totally fine, and we'll be back next week. What a year it has been. By the time you're listening to this episode, I imagine you're perhaps brewing the first coffee of this Martin Luther King Jr. Day weekend, or maybe heading to a protest somewhere, or just walking your dog. By the time you're listening to this episode, President Donald Trump may have invoked the Insurrection Act. The federal government has deployed 3,000 immigration officers to Minnesota, outnumbering members of the Minneapolis Police Department by about 5-1, according to the Minnesota Star-Tribune. The ACLU is suing the administration for racially profiling Minnesotans of color, while reports grow of U.S. citizens being picked up, roughed up, and dumped in retaliation for following or filming immigration agents. The situation is escalating, and the accelerant is not the protesters or the immigrants they're trying to protect, but the federal government. The question now is what happens if the military is thrown into this volatile mix. In a moment, I'll be speaking with Steve Vladeck, a professor at Georgetown University Law Center and great friend of the show, about the Insurrection Act and what we might expect if Trump invokes it.
The Insurrection Act is really about circumstances where the states themselves are either unwilling or unable to enforce their laws, not federal law, or where they're the ones who are specifically thwarting federal law enforcement.
Later on in the show, we're going to stay with events in Minnesota, zooming in on the murder of Renee Good and the Justice Department's abandonment of any efforts to investigate the shooter, preferring instead to investigate Renee's widow. I'll be talking to a former prosecutor from the criminal section of the Justice Department's storied Civil Rights Division. She has some stark warnings about what's happening at Main Justice and what's happening to paths to accountability as a result.
To say from the outset that we're not going to do anything. I believe Todd Blanche, the Deputy Attorney General, made a statement that there was no basis for a federal investigation here. That really just flies in the face of years and years, even decades of best practices.
And we have not forgotten about the landmark arguments at the Supreme Court about who can be discriminated against in school sports. For our Slate Plus bonus episode, I'm digging into the arguments in the big Title IX trans athletes case that was argued Tuesday, speaking to a lawyer who used to write the guidance at the Department of Education's Office for Civil Rights.
The statutory text of the law itself that was passed in 1972 actually says nothing about sports.
You can sign up for Slate Plus at slate.com/amicus plus if you want to join us. But first, the over-under on the Insurrection Act. Yes, President Trump has threatened to invoke it before, and maybe this is like those times. But his lust for soldiers enforcing civilian law in America's streets has been thus far constrained by the courts, possibly making this 200-year-old law more attractive to an administration clearly frustrated by the organized efforts of Minnesotan civilians trying to protect their immigrant neighbors and document the violent excesses of the federal government's masked agents. Steve Loddick is a professor of law at the Georgetown University Law Center and is a nationally recognized expert on the federal courts, the Supreme Court, national security law, and military justice. His Substack, One First, is utterly indispensable reading. Steve, welcome back to Amicus.
Thanks, Mark. I made the grave mistake of writing my student note in law school about the Insurrection Act, and I am paying the price.
Wow, a mistake that reverberates through the decades,
Yep.
I see. And so
Yep.
Here we are today. Just to start, with the absolute basics, tell us, what is the Insurrection Act?
Yeah, so part of the problem is that it's not actually one statute, it's four. And it's not actually only about insurrection. The Insurrection Act is the common, if misleading, name that we've given to a series of statutes that trace all the way back to 1792 that are carrying into force Congress's constitutional power to provide for the calling forth of the militia and then later the military to suppress insurrection, to repel invasion, or, as most relevant here, to, quote, execute the laws of the Union, unquote. And, Mark, the idea was that Congress should be able to allow the president to have very narrow but very poignant, important circumstances where he could use military support and military force as a backup when civilian order and civilian law enforcement has broken down.
So the idea was that it would be used in narrow circumstances, but the language, especially that last part that you read, is actually fairly broad. So tell us about how presidents have invoked it in the past, because it seems like for the most part, they've actually been pretty restrained and not just used it like Trump wants to use it whenever he sees an alleged problem he wants to fix through military might in American streets.
Yeah, so the history of the Insurrection Act is a history of pretty responsible usage of a statute that, as you say, Mark, could be interpreted, if you just read it in a vacuum, actually as a remarkably broad delegation of power to the president. So, we've had, I think, somewhere around 30 invocations of the statute across American history, but the last one was 34 years ago when President George H.W. Bush used it to help send troops in during the Rodney King riots in Los Angeles. But Mark, one of the things about those 30 invocations is that although they might have been, in some cases, politically controversial, they really weren't legally controversial. So just to take one example, when President Kennedy sends troops into Mississippi in 1962 to protect not just James Meredith, the first black student at the University of Mississippi, but the 300 law enforcement officers who were there with him, that was, politically controversial because the South didn't want them. It was not legally controversial because those guys were at perilous risk of being lynched. And, Mississippi local and state authorities were not exactly helping. So part of the problem here, Mark, is that presidents have been responsible historically. Presidents have usually had compelling factual bases for invoking the Insurrection Act. The Insurrection Act hasn't been used as sort of like a permanent way to deploy troops into our cities. Like, these deployments have been brief, and they've been, for the most part, effective. And Mark, even the Justice Department, which, is not exactly shy about claiming power for the president, has taken a very narrow view historically of when they can use it. I'm quoting here from a memo that Nicholas Katzenbach wrote in 1964. He says, where no court order is involved, reliance must be placed on the premise that those engaging in violence are either acting with the approval of state authorities or have, like the KKK in the 1870s, taken over effective control of the area involved. Those are pretty narrow circumstances for calling out troops. And I think we've been lucky historically that presidents have shied away, even in circumstances that might have fit the statute, but not that understanding.
So it sounds like you don't think that the protests in the Twin Cities right now actually give Trump legitimate grounds to invoke the Insurrection Act.
I don't even think it's close. Now, I think, again, this is the problem of folks who are coming to this history new and don't know the backstory and haven't read the Katzenbach memo and don't appreciate the sort of the historical pedigree here. Because you could read the statute and say, oh, well, if I, squint a little, one protester throwing a rock at an ICE officer or protesters pouring water on the streets in front of where the ICE vehicles come out of the federal building, right? That's interfering with law enforcement. That's impeding it. That's making it impossible for them to carry out their duties. But the Insurrection Act is not about private conduct. The Insurrection Act is really about circumstances where the states themselves are either unwilling or unable to enforce their laws, not federal law, or where they're the ones who are specifically thwarting federal law enforcement.
So where does that principle come from, if not directly from the text? Because again, that last provision does sound really broad. Is this a sort of avoidance reading to shy away from constitutional problems that would arise if it were used differently? Is this sort of gleaning it from context and historical use? Where is that coming from?
I think it's a little bit of both. I mean, so again, part of the problem here is that the history is a little complicated because it's not one statute, it's four. And so you have, the statutes that Congress enacted in 1795 and 1807, which were the predicates, which were actually much, much more limited. Then you have the 1861 and 1871 statutes. I mean, Mark, the last time Congress touched this regime, besides a brief, weird sort of try something and then undo it in 2006, the last time Congress touched this regime was 1871. When it was dealing with the KKK. I mean, the statute is literally known as the Ku Klux Klan Act of 1871. And I think the key here is that these powers were given to presidents with an understanding that they weren't pretexts, that you actually had to have real resistance to federal authority, not just by sort of people in a state, but by the state. Because otherwise, the assumption is that the state can carry out its own law enforcement. The state can arrest people who assault federal officers. The state can clear roadways, right? I mean, this is the point, is that there's supposed to be at least some argument, either that the state wants the federal assistance, and here we know it doesn't, or that the state is responsible for the inability of federal officers to carry out their law enforcement duties.
So just to lay it out, based on all the facts we have at hand now, you don't think that the state of Minnesota is interfering with federal law enforcement or obstructing federal law enforcement in the way envisioned by the Insurrection Act?
I mean, not only do I not think that, but even if you look at what the Trump administration is saying, every time they point to an example of something bad happening to an ICE officer, right, or something bad happening in these protests, the culprits are protesters, not state officials. Right. I mean, President Trump can mouth off about, the mayor and the governor and all that, but they don't actually have any specific examples of any policies or any episodes where it has been the state and local governments that have been the reasons why ICE has been in any way impeded. And Mark, if it were otherwise, if one person doing one thing to impede an ICE officer from carrying out their duties was sufficient to justify an invocation of the Insurrection Act, then all protests would trigger the Insurrection Act. That's not how we've ever understood the Insurrection Act. It would not make any sense with First Amendment values. The founders who wrote these statutes would be horrified at that perspective. I mean, that's the problem. Now, the trickier part, which I think we'll get to in a second, is what will the courts do? But, before we get to our friends on the Supreme Court, I think it's worth laying out there's no historical precedent for invoking the Insurrection Act in these circumstances.
And just to linger on this for one more beat, it sounds like you're saying we should be very worried if Trump invokes the Insurrection Act here, not just because of what happens on the ground, but because he has now shattered the precedent set by the federal government and the Justice Department that this is not to be deployed against ordinary protest activity or even protest activity that is getting out of hand, as long as the state is still doing its job more or less of exercising its police powers. And it would just shift a massive amount of discretion to the president to say, I see a protest I don't like, I'm sending in the military.
Right. The Insurrection Act is supposed to be about breakdowns in authority and not protests of the federal government. Just one really quick last thing, because I think there's a little bit of confusion out there, largely because I don't think President Trump understands this. Even if we had, right, Mark, even if we crossed that Rubicon, and even if there is an invocation of the Insurrection Act, it's worth stressing that, that's not like martial law. In the 30 examples historically, when presidents have invoked the Insurrection Act, all that the military is doing is the same law enforcement that other federal officers could already carry out. They're bound by the same limits, right? The First, the Fourth, the Fifth, the Eighth Amendments all apply. If anything, Mark, the military probably has even better and more enforceable limits on their law enforcement powers than ICE does. And so it's not that invoking the Insurrection Act is tantamount to military rule. The danger is the slippery slope that you were alluding to. The danger is that we start sort of normalizing the circumstances in which we're comfortable putting troops on the streets in a context that has historically been understood to be deeply corrosive to civilian control of the government.
We didn't talk posse comitatus. The Posse Comitatus Act generally bars the military from enforcing domestic law in American streets, right?
It does. But the Posse Comitatus Act, Mark, as you know, is really more of a clear statement rule than a categorical restriction. And so when it was enacted in 1878, it was enacted with exceptions, where the default is that it is unlawful to use the military to enforce federal law unless it is specifically authorized by the Constitution or an act of Congress. And, Mark, the specific act of Congress that Congress was thinking of in 1878 when it wrote the Posse Comitatus Act was the Insurrection Act, right? And so when you have a valid invocation of the Insurrection Act, that necessarily overrides the Posse Comitatus Act.
So let's dive into the legal aspect here. And I want to hear first how the Supreme Court's decision in the National Guard case may have inadvertently or not, sort of led us to a place where Trump is threatening the Insurrection Act. Because this was something you and a lot of others flagged when that decision came down. So how does that sort of lead us to this moment?
So this is the Justice Kavanaugh view of the world, right? So in the Illinois National Guard case, the fight was over this other statute, 10 U.S.C. Section 12406, which authorizes the federalization of National Guard troops, so Mark, not the regular active duty military, when the president is, quote, unable with the regular forces, unquote, right, to carry out the laws. I've thought all along that Marty Lederman was right, and that the regular forces there means the Army, not ICE. And Justice Kavanaugh, like a lot of commentators, said, well, if that's the case, aren't we just encouraging the president to invoke the Insurrection Act? Well, historically, no. The 12406 has been on the books, Mark, since 1908, and no one has ever suggested that the correct reading of that statute has led to more invocations of the Insurrection Act. What is missing from this conversation is the role that the state is supposed to play first. When there is some crisis that local law enforcement is not able to handle, Mark, the first reaction is not for the president to send in troops. The first reaction is for the governor to send in the National Guard. This is the system we have and have had since the beginning of the 20th century. And so part of what has been missing all along is that there's this intermediate step where we expect states to restore order themselves, and then the federal government is the backstop when the states either can't or won't. That's the framing here. Now, to the notion that, because President Trump couldn't use 12406, he's more likely to invoke the Insurrection Act, I think that's a bit circular, because what he was trying to do with 12406 was very much the same thing. And so to say, he might now do this other thing, Mark, by the logic you're hearing from the president and his supporters, he could have invoked the Insurrection Act all along.
Yeah.
Right. And there's a reason why he hasn't yet. And it's not because 12406 was somehow this better, more available authority.
So what is the reason?
I actually think there are two, and I think one is political and one's legal. So the political reason is that there really, I think, still are political obstacles to invoking the Insurrection Act, even in our current moment, right? That he would invite blowback, even, I think, from some members of the Republican caucus in Congress. Not many,
yeah.
But Mark, given how razor thin the Republicans' margin is in the House right now, it wouldn't take that many votes, right, to really upend all of this. And then the legal part is, I think there's probably some folks who are wary that the facts as they currently stand make it at least somewhat questionable whether they will win that case, versus a scenario where there's a more visible, say, unprovoked assault on an ICE officer or state official who is directly involved in impeding ICE. I think that might be the pretext they're looking for.
More in a moment with Steve Vladeck.
President Trump doesn't know what to do with courage, but we do. I'm Skye Perryman, President and CEO of Democracy Forward. Since Inauguration Day, our lawyers have been fighting for people and communities, challenging the Trump-Vance administration's unlawful agenda. We've won legal victories already, but this fight isn't just ours. It belongs to the people. And we know the cost of silence is greater than the cost of action. So join us. Add your courage to the cause at democracyforward.org.
This show is brought to you by BetterHelp. The new year doesn't require a new you, maybe just a less burdened you. Therapy can help you identify what's weighing you down by offering an unbiased perspective to better understand your relationships, motivations, and emotions. If you're thinking of starting therapy, give BetterHelp a try. BetterHelp does the initial therapist matching for you so you can focus on your therapy goals. A short questionnaire helps identify your needs and preferences, and BetterHelp's industry-leading match fulfillment rate means they typically find the right therapist for you, but you can switch to a different therapist at any time from their tailored recommendations. Stop carrying your worries all by yourself and start feeling lighter this year with BetterHelp. BetterHelp makes it easy to get matched online with a qualified therapist. Sign up and get 10% off at betterhelp.com/amicus. That's betterhelp.com/AMICUS.
This episode is brought to you by Quince. Starting the year with a wardrobe refresh, Quince has you covered with luxe essentials that feel effortless and look polished, perfect for layering, mixing, and building a wardrobe that lasts. Their versatile styles make it easy to reach for them day after day after day. The quality shows in every detail. The stitching, the fit, the fabrics, every piece is thoughtfully designed to be your new wardrobe essential. Right now, I'm continuing to be completely in love with this lightweight cotton cashmere link stitch sweater that I got in Mountain Spring Blue. I wear it constantly, and I can't wait to gift it to someone else. Refresh your wardrobe with Quince. Don't wait. Go to quince.com/amicus for free shipping on your order and 365-day returns. Now available in Canada too. That's QUINCE.com/amicus to get free shipping and 365-day returns. Quince.com/amicus.
And we're back talking about the Insurrection Act with Steve Vladeck. As of this taping, the Insurrection Act has not yet been invoked. If it is, there will be a legal challenge. Of course, it will go up to the Supreme Court. What will that challenge look like? And do you really think it'll have a chance of prevailing at this SCOTUS? I mean, maybe the National Guard ruling gives some cause for hope, but there has been a lot of chatter about the unreviewability in courts of presidential decision-making in this area. Is there also a chance that justices could say, we just don't have authority to overrule the commander-in-chief on this?
I don't think it will go quite that far. What I worry about more, Mark, is a ruling that says that the president's entitled to a whole lot of deference. And that, not that the courts are powerless. I don't think John Roberts is going to put his name or even sign without his name an opinion that says we are powerless about anything. But I do worry that then we would have the issue that we thought we had in the Illinois case. I mean, until the court issued that supplemental briefing order in the Illinois National Guard case, we were having very much the same fight, which is, the lower courts made a series of factual findings that are inconsistent with what the executive branch has said is the factual basis for invoking 12406. Do the courts have the power to do that? And I think folks were rightly nervous that the Supreme Court might have at least stayed those lower court injunctions in that case. That will be the fight. Now, this is why, Mark, I think the facts actually are going to matter. Is there more of a factual basis than what we have as you and I are sitting here Friday morning for invoking the Insurrection Act if and when the president does it? Does the district court or district courts, do they make factual findings that are actually well supported by the record and would be difficult for the Supreme Court to run away from? Like, part of the devil's going to be in the details here.
So it sounds like you think the justices really don't want to call Donald Trump a liar.
Mark, at least 6 of them don't.
At least 6 of them don't. And one of the great things about Marty Lederman's brief in the National Guard case is that it gave the court an out. They could say no National Guard, at least under these circumstances, but they didn't have to say Trump was lying. And so with the Insurrection Act, there's kind of a similar conflict where in order to block the deployment of the military in the Twin Cities, the court's probably going to have to say that Trump and a lot of executive branch officials and law enforcement officials are not telling the truth about what's happening, and they're really hesitant to do so. But there's no magic out here the way that there was in the National Guard case by, a Lederman brief that simply says, oh, it turns out that you have to try to send in the military first before you can send in the National Guard. They're just going to have to confront these lies head on.
Yeah, I mean, the only thing I can imagine, Mark, is a universe in which even the factual proffers made by the Trump administration could be held insufficient. The only way that I could see the Supreme Court ruling against Trump without second-guessing him is an opinion that says something along the lines of, even assuming all of this is true, that's still not enough for the Insurrection Act. Let me put it this way. I have no faith that Justice Kavanaugh would join such an opinion. I have no faith that Thomas Alito or Gorsuch would join such an opinion. And so we're back to where we are so often in these cases, which is where are the Chief and Barrett?
And where do you think they are?
I don't know. Let me start with the most important point. I've been wrong about both of them before. I'm heartened by what happened in the Illinois case. I mean, I think that is the sign that contra the charge from Justice Jackson, it is not just a reflexive rule for the Trump administration instinct that's governing their votes in these cases. But Mark, I do think that, it's going to really depend on just how divorced from reality the Trump administration's factual arguments are. And that this is why I think they've been waiting for something more than, the Renee Good incident, for something more than, a couple of suspects resisting an ICE arrest. I think they're waiting for something that they can pitch plausibly as a completely unprovoked act of violence and or interference by a local or state law enforcement officer.
Yeah, people often say cynically that Trump does whatever he wants and doesn't listen to his lawyers. And I actually don't think that's true, specifically when it comes to stuff that could reach the Supreme Court.
100%.
I think he is very cautious when dealing with any issue that's going to go to the justices to make sure that he and his lawyers have a solid basis for convincing 5 or 6 of them.
I mean, there's a reason why they haven't invoked the Insurrection Act as we're sitting here yet.
So let's say he does. And there's going to be a period, if he does, before this goes to the Supreme Court and before a court blocks it. So first question, what exactly does invoking the Insurrection Act do to state and local authority, especially if, as here, state officials oppose federal intervention, but also are not committed to obstructing it?
So the short answer is nothing. I mean, this is, I think, a really important point. What it would mean overnight without any judicial intervention is that in addition to I think it's now, Mark, 3,000 ICE officers who are on the ground in Minnesota, there'd also be some troops. And the troops might be with the ICE officers. The troops might be doing things on their own. But Mark, those troops would have ordinary law enforcement powers. They could arrest based on probable cause. They can search. They can execute search warrants. I mean, all of those things. As I think I alluded to before, there's a chance the troops actually might be far more restrained than the ICE officers we've seen. And so, the overnight issue, I think, it's not like you'd wake up in the morning and civil liberties in Minnesota would no longer exist. But it would be a much larger federal presence, even larger than it already is. It would be more people on the streets with guns. And it would be a remarkably new precedent for what the president might try, Mark, in other contexts, including maybe as we get closer to elections.
So what constitutional rights would be most immediately at risk? I mean, I hear you saying it's kind of complex because troops might be better behaved than federal immigration officers. It still seems like sending the military into American streets could threaten free speech, free assembly, due process. I guess also on the other side, you've got state sovereignty, which at least until recently, the Supreme Court assured us was a matter of great constitutional importance. Are those things in peril once the Insurrection Act button gets pushed?
So at the risk of saying something controversial, I think the state sovereignty issues, when the Insurrection Act is lawfully invoked, are necessarily overridden, right? And so take the Mississippi example from 1962 again. Obviously, President Kennedy sending troops into Mississippi to desegregate the University of Mississippi was a massive intrusion into the sovereignty of Mississippi. And Mark, we didn't care.
Yeah. Mississippi deserved it.
Well, or at least, at the very least, right, Mississippi was failing to enforce federal law itself, and therefore, right, Mississippi was failing to abide by federal law. Therefore, it lost any state sovereignty argument. The precedent we're setting here, or we would be setting here, is overriding state sovereignty in a context in which the state had not been responsible for the undermining of federal law. And I think that's not necessarily, Mark, a constitutional line. It is certainly a historical one. And, one that I think would set an ominous precedent going forward if it were upheld.
What about individual rights? I mean, surely sending uniformed soldiers into the streets is going to have at least some chilling effect on freedom of speech and assembly, right?
I think that's certainly true, although I think we're already seeing some of that from ICE in Minnesota. The stories I'm hearing about people who won't leave their homes, right? That's true whether they're wearing an ICE patch on their, sleeves or whether they're wearing a flag. I guess, the First Amendment issues are significant. I think the larger challenges, those would be as applied challenges, Mark, right? Those would be like if the troops are behaving in a way that is sort of especially interfering with, speech, assembly, etc. I really think the facial challenges are going to end up being more statutory than constitutional because for better or for worse, the constitutional accommodation here is that there are circumstances where the federal government is allowed to trample on the states. And so the real question, I think, is, are these the circumstances in which Congress has authorized that? And that's where I think much of the battle will be joined.
So if the troops are deployed, what exactly are the rules that govern their use of force? And how are those different from rules that govern ordinary civilian policing, to the extent there are any rules that govern federal immigration agents these days?
Well, there are rules; they're just not enforced. Right? I mean,
right.
ICE has excessive force regulations. They just don't follow them. So, the military, Mark, has its own rules of engagement. There are rules that are specific to the military about what they can and can't do. I would say, Mark, it's probably likely that the military is better trained about when they can and can't use potentially deadly force than ICE is. But, I think the reality is those rules are going to be hard to litigate for the same reasons that they've been hard to litigate in the ICE cases. It is no easier to obtain, for example, damages because the military has violated your constitutional rights than because ICE has. If anything, it's even harder.
We know back in 2020, in Trump's first term, he wanted to know whether the military could shoot protesters in the legs.
No.
Okay, good. Clear answer on that. Maybe you should be advising the president, Steve.
That wouldn't be good for my blood pressure.
Trump's former defense secretary, Mark Esper, told NPR that he stayed in his job at that time because he was worried about what might happen if he left. Pete Hegseth now has that job, which is frankly terrifying. We've already seen these illegal boat attacks that have not carried any accountability so far, but somebody was prepared to pull the trigger up to and including, reportedly, a double tap. What message does all of that send to members of the military who may now be deployed against their fellow citizens?
It's a great question, and I don't even know where to begin trying to answer it. I think the first thing to say about the boat strikes is there actually was some pushback, right? We now know that there were senior military officers who resigned in protest over what was happening. I think we probably see some of that in a domestic deployment as well. I mean, again, I think, Mark, the real question in any domestic deployment of the military is going to be to what extent Hegseth and, the Secretary of the Army or whoever the combatant commanders are override the traditional rules, right? To what extent they say, we're actually not going to follow the traditional limits on, uses of force in these circumstances. And I think if that happens, Mark, it will be a scandal and one that we will know about quickly because it will surely provoke some members of the military to publicly and loudly resign. It will provoke dissension in the ranks. I think, Mark, even folks who are comfortable participating in operations to use lethal force against suspected narco traffickers on the high seas are going to have a little bit of pause when it comes to using troops against our own people on our own cities and our own streets.
I'm sensing a little bit of tension in your answers, and I feel it too. And that tension seems to be that you really don't think Trump should invoke the Insurrection Act. You don't think he has the authority to do so here. But at the same time, you maybe trust the military more than immigration agents?
Yes.
Why is that?
Why is that? A couple reasons, right? They have much more training. There is much more robust internal discipline. However difficult it is to sue the military for damages, there is a robust internal process by which military service members who misbehave are subject to discipline. And that's not a political decision by Secretary Hegseth, right? That is a unit decision by unit commanders, most of whom are insulated from direct political interference. So, there's a tradition of at least internal accountability in the military, Mark, that is by no means perfect, but that, puts ICE to shame. There's a culture of following the rules in the military that I don't think is remotely what we see in ICE. Just to be in the military, you have to go through a heck of a lot more than you do to apparently become an ICE officer. And so I think, what all of that lends itself to is just a sense that we haven't necessarily tested recently, Mark, that the military is going to be less likely to abuse its authorities in the law enforcement space than ICE has been. On the flip side, it has been 34 years since any American troops were in this position. And, whether what had been true historically will remain true today, I think is an open question. But at least the historical precedents are that, troops who were called out under the Insurrection Act tended to behave pretty well.
And I guess on the optimistic side of the ledger there, we know that ICE has a flood of new recruits who are totally unqualified, largely untrained, unaccountable.
Even writers for Slate, right?
Yes, indeed. And we're so proud to have an accepted ICE officer as a Slate byline now. But Pete Hegseth has not yet had time to pack the ranks of the military with thugs of the kind that we've seen in ICE and CBP under the banner of his new kind of warfighting ethos, right?
So far as we could tell, that's right. I mean, so this at the senior levels, maybe. But again, it's not going to be the lieutenant generals and the colonels who are the ones who are out on the streets. This tension here, I think, is worth just sort of saying one more thing about, which is, I'm less worried that an invocation of the Insurrection Act is going to make the situation on the ground worse. I am more worried that it's going to create a really ominous precedent going forward where we break the seal and where it just becomes a more common thing that presidents do that gets us more desensitized to how extraordinary it is and has been historically to have, uniformed members of the U.S. Army and the U.S. Marine Corps on our streets.
You've represented service members. You're probably representing them right now. What advice would you give to those men and women in uniform if they are sent out into the streets of the Twin Cities under the Insurrection Act?
I think the best advice is, unit cohesion really matters. Talk to your commanders. If you need access to counsel, there are hotlines that are available. There are resources for soldiers who have questions about whether particular orders might or may not be lawful. I will just say, Mark, I think there's going to be a big difference between whether soldiers can and should push back against a deployment order, where I think the answer is probably not, like that's what the litigation will be for, and whether we get to a point where there are specific orders coming down the chain of command to use force in circumstances in which the soldiers don't think it's justified. The latter, to me, I think, are the much harder cases than the former.
Service members who are listening, Steve Vladeck is probably not your lawyer, but he is a lawyer, and he has some very wise words for you. Steve Vladeck is a professor of law at the Georgetown University Law Center and is a nationally recognized expert on the federal courts, the Supreme Court, national security law, and military justice. And you absolutely must read his fantastic Substack, One First. Steve, thank you so much for joining us.
Thanks, Mark.
We're going to take a short break. When we come back, a slew of resignations from the United States Attorney's Office in Minnesota and what they tell us about how things are going at the Justice Department in the wake of the murder of Renee Good. Stick around. One week after an ICE officer shot and killed Renee Good in her car in South Minneapolis, the New York Times released more analysis of multiple videos of the killing, some from footage taken from a previously unseen angle. I have watched it, and it is so very clear that Renee Good neither rammed ICE officer Jonathan Ross nor ran over him. But the Civil Rights Division of Pam Bondi's Justice Department doesn't care. The division has refused to investigate Ross, the officer who shot Good in the head, and instead reportedly directed the local U.S. Attorney's Office to investigate her widow for potential criminal charges. In response, at least 6 career prosecutors have resigned from the office, a stunning and highly unusual rebuke to the administration. Julia Gegenheimer served as an assistant special counsel and as a special litigation counsel in the Civil Rights Division's criminal section. With the Civil Rights Division, Julia prosecuted complex federal civil rights violations, including constitutional violations committed under color of law and hate crimes, with a particular focus on cases involving extremism and domestic terrorism. She's now special litigation counsel at Georgetown Law's Institute for Constitutional Advocacy and Protection. Julia, welcome.
Thank you so much. Thanks for having me.
Just to set the table, could you explain the kind of work that you did at the Civil Rights Division when it was under very different leadership?
Sure. And I will say here, I was by no means the longest serving attorney in that office, but even during my tenure, I served under multiple administrations, Democrat and Republican, and that was generally par for the course for the attorneys that I worked with. And over those years, the mandate of the criminal section of the Civil Rights Division, which is the specific office where I worked, was fairly targeted. The office focused on investigating and prosecuting instances of law enforcement misconduct that would range from excessive uses of force that were minor assaults all the way up to what we saw in Minneapolis, an officer-involved shooting. The office also investigated federal hate crimes violations and human trafficking violations.
Just to be super clear, after a federal agent shoots and kills a civilian, normally the Civil Rights Division would at least open investigations, right?
Absolutely. Particularly where there is a federal officer involved. The office also investigates police-involved shootings involving state and local officers, but especially here where there's a federal officer, it's an incident that's garnered so much national attention and has impacted so many communities. I mean, this is a scenario that is just ripe for involvement of criminal section from the Civil Rights Division.
My understanding, and correct me if I'm wrong, is that the Civil Rights Division isn't going to get involved with every incident at the state or local level in which state or local cops shoot and kill someone. Usually they will reserve intervention for if there seems to be some major civil rights violation or some pattern or practice of violations. But when a federal agent shoots and kills someone, the Justice Department, and specifically the Civil Rights Division, needs to investigate, because otherwise it's very difficult for any other agency, especially at the state or local level, to do so. Like, you're pretty much the first point of contact when a federal agent kills someone in the field, right?
Yeah, I mean, I think I would agree. DOJ is best positioned in that specific scenario that you just described to be the ones to go in to lead an investigation to determine if there's been a violation of federal law. And because there are significant challenges in a state investigating and prosecuting a federal officer, the path toward accountability is the most straightforward at the federal level. Typically, that involves a partnership between attorneys and investigators from Main Justice, from the Civil Rights Division, and from the local U.S. Attorney's Office and the FBI in the area where the incident occurred.
The current head of the Civil Rights Division, Hermeet Dillon, who was appointed by Donald Trump, is refusing to even open a probe into the ICE agent who shot Renee Good. What do you make of that?
To say that it is highly unusual, I mean, even as I say that, is a huge understatement. I think one of the things that the attorneys who investigate and prosecute these cases know very well is that it's almost impossible to judge a case from the outset. The attorneys there have seen cases that look impossible break open and become prosecutable, and they've seen the reverse, cases that look promising that after a fair and thorough investigation, they determine are not prosecutable or they decline to bring charges. So to say from the outset that we're not going to do anything, I believe Todd Blanche, the Deputy Attorney General, made a statement that there was no basis for a federal investigation here. That really just flies in the face of years and years, even decades of best practices.
When the deputy AG says there's just no basis to open an investigation, that means he believes it's such an open and shut case that there was no civil rights violation or any other crime committed here, that the Justice Department need not even glance at the possibility of an investigation, that it's the simplest call in the world to say, no problem, we're wiping our hands of this. That's what he means when he says there's no basis, right?
That's how I interpret it. The other interpretation would be that there's no possibility of a federal crime having been committed here, right? There's no legal possibility. But no matter how you look at it, that's not a call that you can make from the outset based on, a few videos. Now, certainly I'm not privy to the material that anyone inside DOJ has been able to review or has reviewed so far, but statements like that, particularly coupled with statements from DHS officials and other administration officials hours after the incident occurred, basically coming out and saying there's nothing to see here, there was no crime committed here. I mean, it's impossible to make that ultimate determination so quickly. particularly when during the normal course of things, this is something that smart, experienced investigators and prosecutors would investigate for months to be able to reach that determination.
And yet, instead of investigating the officer who shot Good on camera, the Justice Department is reportedly investigating Good's widow for some unknown alleged crime, which looks a lot like retaliation. We know that as of this taping, at least 6 prosecutors from the Minneapolis U.S. Attorney's Office have resigned rather than pursue this investigation. Can you explain just how unusual it is to see career prosecutors resign en masse like this?
These are people, I mentioned earlier in the context of the Civil Rights Division, these are people who are dedicated to the mission. They're not political. In many cases, in both the Minneapolis U.S. Attorney's Office and in the Civil Rights Division, these are people who have served over multiple administrations. And frankly, they love their job. They're used to working hard. They're used to doing hard things in the course of their job. So these are not people who are just going to resign at the drop of a hat. They're really dedicated public servants. And so to be pushed out like that really takes something notable and extraordinary.
You say pushed out. I mean, it looks like resignations in protest, right? Is there any other way to interpret this? I know that the administration has stayed somewhat tight-lipped about it, and there's actually been a lot of hand-wringing among law enforcement in the area that these prosecutors were really important to investigating and prosecuting actual crimes committed on the ground. This looks like the prosecutors deciding that even carrying on that good work cannot be justified if they are required to open obviously partisan investigations into a grieving widow because her wife was shot by ICE and she needs to be vilified, right?
What I mean by pushed out is just repeatedly or even once being asked to do something that is unlawful, unethical, unprofessional. Longtime prosecutors in particular are sort of imbued with these ethical obligations that we have to conduct ourselves by. And so, when you are required to do something that you know is unethical or that you believe is wrong, that's what I mean by pushed out.
You spent years working on cases involving domestic terrorism and extremist violence. Deputy AG Todd Blanche, who we've been talking about this week, described Minnesota Governor Tim Walz and Mayor Jacob Frey as being engaged in terrorism. I want to play a clip from Governor Walz's address on Wednesday night. This is the kind of language he's using.
We must protest loudly, urgently, but also peacefully. Indeed, as hard as we will fight in the courts and at the ballot box, we cannot and will not let violence prevail. You're angry, I'm angry. Angry is not a strong enough word, but we must remain peaceful.
Meanwhile, here's the exact language from Blanche's post on X. Quote, Walz and Frey, I'm focused on stopping you from your terrorism by whatever means necessary. This is not a threat, it's a promise. We've been talking a lot about this on the show, but I'm curious for your thoughts. What happens when almost anyone can be classified as a terrorist and any opposition to the government, including protected First Amendment activities, can be classified as terrorism?
Yeah, I think it's important here when we talk about domestic terrorism to sort of take a step back and look at what we actually mean when we use that term. Because it's being thrown around a lot, and it's kind of in common parlance come to be a stand-in almost for people who are opposed to this administration or its policies, or who are protesting this administration or its policies, or frankly, who are seeking to hold this administration accountable. But federal law actually defines domestic terrorism. So under the law, domestic terrorism involves activities that are dangerous to human life, that are in violation of federal criminal law, and that on top of that have some sort of motivation or intent to intimidate a population, to affect the conduct or the policy of a government by intimidation or coercion or violence. That is the definition under federal law. And even then, domestic terrorism is not itself a federal crime, right? You have to have an underlying federal criminal violation, and then these additional layers of motivation or intent on top of it. So I think the impact of sort of throwing this term around very loosely is that it allows the people deeming others domestic terrorists or involved in domestic terrorism to essentially criminalize them when in fact their conduct falls far, far short of what federal law would actually look at as domestic terrorism.
We've seen the president and his allies calling these protesters terrorists now for quite some time. We've seen the government treating protesters like Renee Good, much as they treated the fishermen in boats in international waters who they bombed without any semblance of due process. It feels to me like an escalation to then accuse elected local and state leaders of terrorism.
It is profoundly disturbing, and I think the reason why this feels different to you is that it is a bit of a different flavor. I mean, it's pitting the federal government against the states and creating this tension where it doesn't need to be one, and frankly, encouraging acts of political violence, implicitly encouraging acts of political violence against these elected officials by turning them into the enemy.
So we have the Trump administration falsely accusing state and local leaders of encouraging political violence, and in the process actually encouraging political violence against the people they're defaming.
Sure. And I don't want to sit here and say that I have a quote from a federal official that explicitly encourages political violence. But as we've seen throughout history, even recent history, when you put people in opposition like that, when you portray them as the enemy, when you describe them as kind of threatening a person's way of life or things that they hold dear, when you other them like that, that creates the conditions under which people are more likely to resort to political violence, where they're so desperate that political violence becomes more and more the norm.
And it feels very much of a piece with the Trump administration treating blue states as the enemy of this federal government, somehow of the American people, shutting off federal funds to blue states, canceling projects within blue states, trying to suppress the votes of blue state residents. It's direct hostility and antagonism toward the half of the country that didn't vote for him, and refusing to acknowledge the legitimacy of who those people did vote for, which is people like Tim Walz. This is not something that anyone can answer without a functioning crystal ball, but it seems to me it leads to a really dark place when the federal government can almost declare war on a state because it didn't go for him in the most recent election and occupy that state with federal agents who are actively hostile toward and in fact violent toward the local community.
Well, that is what we're seeing. And I think officials in this administration have been explicit about that they are targeting blue states. We've seen the surges in now Minnesota, in Chicago, in Washington, D.C. And the reasoning behind that has been that these are traditionally blue states or Democratic areas. So I don't think it takes too much reading between the lines to see that that is what's going on.
In his address to Minnesotans on Wednesday night, Governor Walz urged people there to bear witness and help to create a record. That record, of course, is vital in prosecutions, should they ever happen. But at the same time, the Trump administration is telling citizens that following or recording ICE officers is a federal crime, that it's an obstruction of law enforcement to follow them and to document what they are doing. Is that true?
That is something that has been long and well recognized as protected by the First Amendment. There is a line between somebody recording law enforcement from a safe distance, say officers are attempting to make an arrest without impeding their ability to make an arrest. So I don't want to say that just because someone has a phone in their hand or a camera in their hand means that anything they do is protected. But the act of observing officers, of recording officers, that is First Amendment protected activity.
Can you just talk about why? I think this gets lost in the conversation, and there's a wrinkle here of using 21st century technology that the framers couldn't possibly have conceived of. But it does seem like this is kind of bedrock First Amendment stuff, right? That the First Amendment isn't just I don't know, buying elections if you're a corporation or a billionaire, that in fact, regular people have a right, if not a duty in a democracy to document what public officials, very much including agents of the state, are doing when they are on the job. Is that overly optimistic to believe that that feels like a core First Amendment principle, or is this something that the law pretty much bears out?
I mean, I think that's something that the law bears out, and it's connected to the idea that people have a right to know what their government is doing, to express their views on what government is doing, to protest peacefully against what their government is doing. I mean, those are all certainly this idea of cell phone recordings of ICE activity is very much a now issue, but it all connects back to these really fundamental principles that the First Amendment was designed to protect.
ICE is claiming that these recordings are obstruction, and the Justice Department is claiming it's illegal obstruction. At the same time, we're seeing ICE try to do their own surveillance of protesters in a much more invasive and I think legally dubious way. There's been a ton of reporting about immigration agents using digital surveillance to identify and harass protesters. It seems like these agents have access to secure databases with extraordinarily sensitive personal information that's meant to be used for legitimate law enforcement purposes. Minnesota says that it's not sharing this information with federal agents. We don't know exactly how they're getting it. How far outside the norm is this? Is this a real departure from how those databases have traditionally been used and how federal law enforcement has used personal information for surveilling demonstrations?
You know, in terms of my past practice, I'm not familiar with the specific databases that are being used now. In terms of the government's access and law enforcement's access to citizens' personal information, I think that ties into this greater phenomenon that we're seeing, which is the loss of a presumption that our government is acting in good faith. It's true that law enforcement has access to a lot of personal records of various people. In my past practice, it was never a question that any of that would be accessed or used for improper purposes. And I think we're seeing that presumption fall away a little bit. You know, in terms of surveillance of protesters and people who are opposed to the administration, you know, this was a lesson that DOJ and the government was meant to have learned from the Hoover era, right? When the FBI engaged in, frankly, unconstitutional covert surveillance of Black leaders and civil rights organizations. But what we see is, you know, now we're coming back around to the government identifying groups of people that it believes are opposed to its goals and resorting to any means that it sees fit to surveil those people, investigate those people, charge those people.
So we're also seeing a flood of videos showing federal agents using wildly disproportionate force against both suspected migrants and protesters engaged in First Amendment activities. What is your reaction to that? And also, would that normally lead to scrutiny from the Civil Rights Division?
To answer the second part of your question, yes. If there are individual instances that merit investigation, that's something that the criminal section would look into. The Civil Rights Division also looks into what are called pattern and practice investigations, looking at sort of overall trends or practices and policies of departments. So absolutely, that would be something that at the very least would be investigated. I think the broader phenomenon is in some ways not surprising because you're sending in an enormous number of agents. I'm not sure at this point what kind of training those agents are receiving. You know, I've seen reporting that the training requirements are being cut. I know that there is an incredible push to recruit new officers to ICE and get them on the streets as quickly as possible. And you're sending them out into these incredibly volatile situations where the communities are fed up with the presence of immigration officers. And then on top of that, you have even public statements by DHS officials and administration officials declaring that these agents are immune from prosecution and essentially talking them up as if they were military forces. So in some ways, the fact that we're seeing so many uses of force against citizens in the places where DHS is operating is not a surprise.
On Thursday morning, Donald Trump threatened to invoke the Insurrection Act to, quote, put an end to the professional agitators and insurrectionists who are allegedly, quote, attacking the patriots of ICE. As of this taping, he has not yet invoked the act. He seems to be on the brink of doing so. It seems to me quite possible that this threat that the president has lobbed is really an effort to normalize military force against political opposition, even political opposition engaged in constitutionally protected activities under the guise of law enforcement. Does that worry you? And could that precedent lead to even darker places?
Of course, that worries me. The use of military forces against one's own population is contrary to what this country stands for. And it should worry anyone and everyone, no matter, their political leaning. I think it's a very dangerous place for our country to be.
The Justice Department has lost a lot of people, including you, over the last year or so. We know it's been bleeding attorneys. It's very much short-staffed. What is the starkest evidence that you've seen over the last year that all of these people leaving the Justice Department, all of this lost experience and wisdom accumulated over the years is having an impact on how cases are being litigated and won or lost?
That's a great question. I think what we've seen, and I can speak mostly to the criminal prosecution side of things, is we've seen abnormal outcomes in cases at almost every level. And actually, what almost disturbs me more, you can talk about cases that a grand jury has declined to indict, cases that petit juries have acquitted on, that maybe you can read into that a degree of jury nullification. But almost more disturbing to me are the cases in which the normal process isn't being allowed to play out, and civil servants, prosecutors who have been in the department, who are just trying to do their job, are being thwarted. So, you look at cases where prosecutors are being directed to dismiss cases, where political officials in DOJ are directing prosecutors to ask for a certain sentence that is not consistent with the sentencing guidelines. There was a civil rights case in Tennessee that was set for trial, and the prosecutors were out there preparing for trial, and the case was dismissed over the line prosecutor's objections before trial. All of this should be raising red flags, not only to people who are familiar with how the Justice Department should work, but to people who care about the rule of law and who care about being safe and being secure in their communities.
Ever since day one of Trump's second term, people have been trying to warn of how dangerous his lawlessness could actually be and how weak some of the guardrails that we assumed existed really were. As someone who investigated January 6th, you were, I'm sure, worried about all of this before day one of Trump 2.0. But it feels like the demolition of norms and institutions and guardrails is becoming very, very, very visible right now. Masked agents demanding citizens show their papers, violently assaulting them, kidnapping them, taking them to some unknown facility where they can't even contact their family. So I'm curious, when the Civil Rights Division was gutted, did you fear that we'd end up seeing something like this?
I fear what happens whenever there are experienced, ethical public servants who are being forced out of a job that they have done and would, under normal circumstances, continue to do faithfully. What you lose when people like that are no longer in the department or in government is not only do you lose their experience, but there's a culture of conducting yourself ethically, with integrity, calling out what's normal and what's not normal, pushing back where you need to push back. And you lose that when you lose people who have been around for a while, who have done difficult cases, investigated and prosecuted difficult cases under difficult circumstances, and who have just been inculcated with that culture. And so I think when that is gone, and my experience is with DOJ, but I'm sure it applies across the government. When that is gone, then you have a government that's become a little bit unmoored.
Would you say that you're surprised or even shocked that a culture that took so long to build up in the Justice Department could wind up being torn down so quickly?
I think it makes me really sad, and it makes me very worried for the future of DOJ and FBI. It's something that we all should be concerned about, because these are the people who do their jobs, do them very well, do them under incredibly difficult circumstances, and they do it to keep us safe, and they do it to preserve, the constitutional norms of our country. It's surprising and disappointing, just the degree to which the department is being dismantled. But above all, it's just very, very sad.
I think you've laid out why and how the Justice Department has been corrupted by this administration. I mean, we've seen courts now, multiple federal judges calling out Justice Department lawyers for lying to them, making misrepresentations under oath. The Justice Department is very rapidly losing the trust of the judiciary and the American people, I think. And I'm curious, what happens when a kind of major organ of accountability, some might say the major organ in American society and government, what happens when all of that collapses almost overnight? And we're left with a situation where the Justice Department is one and the same with Donald Trump and his closest allies, and follows his rule to the letter, and greenlights brutality against protesters, and pushes out prosecutors when they won't retaliate against perceived political foes. Is there a way back from this? I know that's a huge question. I'm not expecting you to give us a step-by-step framework, but is there a future in which the Justice Department is returned to a position where it can at least sometimes be trusted to actually enforce the law for everyone? And if so, how do we get there?
That is a question on the minds of many, many people these days. A lot of former DOJ, former federal government public servants. I think what you described is right in that DOJ and DOJ attorneys are losing that presumption of regularity. They're losing that almost automatic credibility that they have when you step into court and you announce yourself on behalf of the United States. And that is a huge loss. It's something that took years, decades to build up in the eyes of the judiciary. And it's something that is crumbling day by day with each sort of finding of unethical behavior or what have you. So it's an enormous loss. And I think it's, it highlights one of the reasons why it was so important to have this separation between DOJ and the political branches and the White House, why the independence of the Department of Justice and of the FBI was something that everybody strove to respect, because we didn't want to return to a situation where DOJ was just an attack dog for the White House. Now, in terms of how to build that back, the one thing that I remain extremely hopeful about is that we've talked about these personnel losses from DOJ, but those people aren't disappearing into the ether. They're still around. They still have that experience. They're not applying that experience to government currently. But I know that if we get to a point one day where those people can return to government, we'll have the experience. We might not have the infrastructure. We might have to rebuild the infrastructure, but there is a great willingness to do that. And I'm hopeful that even though it will require an enormous amount of effort, that is something that is achievable, kind of rebuilding or building a new version of government and DOJ that abides by ethical norms and professional norms.
Julia Gegenheimer is Special Litigation Counsel at Georgetown Law's Institute for Constitutional Advocacy and Protection, and previously served at the Justice Department's Civil Rights Division. Julia, thank you so much.
Thank you for having me.
That's all for this episode. Thanks so much for listening. And thank you so much for your letters and questions. Keep them coming. We are reachable by email at amicus@slate.com. And you can find us at facebook.com/amicus podcast. You can also leave a comment if you're listening on Spotify or on YouTube, or rate us and review us on Apple Podcasts. On today's Amicus Plus bonus episode, the landmark arguments at SCOTUS this week that are in danger of getting lost in the mix. I'm talking to Mary Rowe Miller, a former Department of Education Office for Civil Rights lawyer, about trans athletes, Little v. Hecox, West Virginia v. BPJ, and how very misguided some of the justices were about the purpose and reality of Title IX in school sports. You can subscribe to Slate Plus directly from the Amicus show page on Apple Podcasts and Spotify. Or visit slate.com/amicus plus to get access wherever you listen. That episode is available for you to listen to right now. We'll see you there. Sarah Birmingham is Amicus's senior producer. Our producer is Patrick Fort. Hillary Fry is Slate's editor-in-chief. Susan Matthews is executive editor. Mia Lobel is executive producer of Slate Podcasts. And Ben Richmond is our senior director of operations. We'll be back with another episode of Amicus next week.
AI is transforming customer service. It's real and it works. And with Fin, we've built the #1 AI agent for customer service. We're seeing lots of cases where it's solving up to 90% of real queries for real businesses. This includes the real-world, complex stuff like issuing a refund or cancelling an order. And we also see it when Fin goes up against competitors. It's top of all the performance benchmarks, top of the G2 leaderboard, and if you're not happy, we'll refund you up to $1 million, which I think says it all. Check it out for yourself at fin.ai.
Did you know that parents rank financial literacy as the #1 most difficult life skill to teach? Meet Greenlight, the debit card and money app for families. With Greenlight, you can set up chores, automate allowance, and keep an eye on your kids' spending with real-time notifications. Kids learn to earn, save, and spend wisely, and parents can rest easy knowing their kids are learning about money with guardrails in place. Sign up for Greenlight today at greenlight.com/podcast.